Probate Presumption of Revocation by Destruction. The estate of Mimi Milka Yaksik, also known as Berger, 2025, New South Wales Supreme Court 253 Hammerschlag Chief Justice. This case concerned an application for a grant of probate of a missing will and codicil. The deceased was a Serbian immigrant and a well-known artist who left a sizable estate in excess of $24 million comprising of real property, cash, and her art collection. Facts. The deceased signed a will on the 22nd of May 2015, appointing her niece Bozica and Bozica's son, Dusko, as joint executors. Under the will, Bozica and Dusko were left all the deceased's real property, bank accounts, and residue of the estate. However, the original will could not be found. A copy of the will was located, which showed that it was validly executed under Section 6 of the Succession Act 2006, New South Wales. On 14th June 2022, the deceased prepared a document titled Codicil to My Last Will and Testament of Mimi Jaksik Berger, also known as the Codicil. Under the codicil, the deceased left her property in Surrey Hills to Mr. Sarja Jankovic and Mrs. Gordana Jankovic, who were close friends of the deceased. The codicil stated that the deceased's original will was held by a solicitor in Kagara. The codicil was not witnessed. On 22nd May 2023, the niece of the deceased lodged a probate caveat to prevent probate being granted to Dusko. Then, on 27th July 2023, Bozica signed a renunciation of probate. Dusko brought these proceedings to remove the caveat and sought for probate to be granted of the copy of the will and codicil. Since the original will could not be found, the issue was whether the presumption of animo revocandi, meaning intending to revoke it, applied, and if it did, had the presumption been rebutted. This presumption arises where someone dies leaving a will that cannot be found, which was last known to be in his or her possession at the date of death. His Honour considered the facts and evidence and held that the presumption had not applied in this case, and if it did apply, it had been rebutted. The deceased had prepared a number of previous wills before the will and codicil were executed. Some of these older original wills were being held by solicitors, and others had been removed by the deceased. One of these wills left a legacy for the Jankovics to benefit from the deceased's estate, which was submitted into evidence of the deceased's testamentary intentions. The evidence established that the deceased believed that the original will was in the possession of her solicitor. In September 2018, the deceased gave authority for her previous solicitors to release her file in relation to her wills to the Kagara solicitor. On 18th July 2022, the deceased stated to another solicitor that the will was held by the Kagara solicitor. In July 2022, the deceased made a similar comment to her friend Gordana Jankovic. The codicil also states that the original will is held by the Kagara solicitor. His Honour ordered for the probate caveat lodged on 22nd May 2023 to be withdrawn and for probate in solemn form to be granted of the copy of the will dated 22nd May 2015 and codicil dated 14th June 2022. For any assistance, please contact MJM Lawyers, your trusted New South Wales wills and estate lawyers, led by our founder Michaela Money, who became a solicitor in 1998 and has been an accredited specialist in wills and estates since 2009. Visit www.mjmlawyers.com.au to book an appointment or call +61 280 3139. With a wealth of experience, Michaela Money and the team are here to guide you with confidence. Liability limited by a scheme approved under professional standards legislation. Disclaimer. This post contains information of a general nature only and is not intended to be used as advice in relation to a specific matter. Although every care has been taken in preparing the document, it may not be accurate or complete, particularly in the context of specific circumstances. MJM Lawyers disclaims responsibility for any errors or omissions.